Welcome all, this is Learn Something New. In this video we understood what is coercion, undue influence, fraud, misrepresentation, and mistake. To clear understanding, don't skip this video. In previous video we understood what is contract, essential elements of valid contact, free consent. Previous video link is in description box. Let's go into the concept. Coercion. The word coercion is clearly explained in Section 15 of the Indian Contract Act, 1872. Define the term coercion as, coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement. Coercion means committing or threatening or emotional blackmail to commit any act is forbidden. It is voidable under the Contract Act. Two types of coercion. Deterrence. Example, don't do. Compellence. Example, do. Blackmail, start doing. Coercive diplomacy. Stop, undo. Example for coercion. A tells B he will hurt him if he doesn't give him his car. B gives A his car, causing his agreement to be coerced. Next concept is undue influence, is mentioned in Section 16 of the Indian Contract Act, 1872. Define the term undue influence as, a contract is said to be induced by undue influence, where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other, and he uses that position to obtain an unfair advantage over the other. Undue influence means an equitable doctrine that involves one person taking advantage of a position of power over another person. The contract is made by the mental pressure of the party made by another or opposite party. The two elements of undue influence they are, first point is must be a relationship of trust, confidence, or authority between the parties to the contract. Second point is the stronger party must wrongfully dominate the party or use unfair persuasion in order to secure an agreement. Example for undue influence is a father exerts undue influence upon his son to do something on the will of his father. The next concept is fraud. The term fraud is clearly explained in Section 17 of the Indian Contract Act, 1872. Fraud means deceit by one of the parties, that is, when one of the parties deliberately makes false statements. Doing mistake and false statement by knowing it is wrong with full consciousness. A contract, consent to which is obtained by fraud, is voidable. Maintaining silence is also fraud. But also, mere silence is not fraud in some cases. Example is, H sold to W some pigs which were to his knowledge suffering from fever. The pigs were sold with all faults and H did not disclose the fact of fever to W. Held there was no fraud in this case. Silence is fraud when 1. Duty of person to speak. 2. Where the silence itself is equivalent to speech. Some say misrepresentation and fraud are same, but misrepresentation is not a fraud. Next concept is misrepresentation. It is explained under Section 18 of the Indian Contract Act, 1872. Misrepresentation means a misrepresentation is a misstatement of the facts. A small difference between fact and fake. In this case, a person who make a contract strongly believe that it is a fact, at last he analysis it is fake. Misrepresentation is about giving of inaccurate information by one party or their agent to the other before the contract is made, which induces them to make the contract. The person making the statement believes it to be true, although it is not true. Misrepresentation is not a fraud, but also, the contract is voidable. Example for misrepresentation. Suppose A and B enter into a contract, wherein A sells his father's car to B, saying that it was purchased from Korea for 5 lakh rupees. Here, A himself has no idea that the car was purchased from Germany. In this case, the statement made by A was untrue but innocent. The next concept is mistake. It is explained under Section 20, 21, 22 of the Indian Contract Act, 1872. Mistake may be defined as innocent or erroneous belief which leads the party to misunderstand the others. Mistake may be either bilateral or unilateral. Bilateral mean mistake by both the party. Unilateral mean mistake by one party. If the contract made by the party has mistake, then it is void contract. Mistake of law. Mistake of law is a legal principle referring to one or more errors that were made by a person in understanding how the applicable law applied to their past activity that is under analysis by a court. Mistake of fact. Mistake of fact arises when accused misunderstood some fact that negates an element of crime. To avoid the mistake in contract, it is essential for the creation of a contract that both the parties should agree to the same thing in the same sense. Example for mistake: A agrees to sell to B his buffalo, but at the time of the agreement, the buffalo had already died. Neither A nor B was aware of this, and so there is no contract at all, i.e., the contract is void due to a mistake of fact. Now you know what is coercion, undue influence, fraud, misrepresentation, and mistake. By this I end this video. Slide is available in the link in description box. In next video I discuss the interesting topic. Thank you. If you like this video, like, comment, and share, but don't forget to subscribe.